Good morning to all of you. Honorable Kerala High Court Justice P.V. Kunhi Krishnan, yesterday, that is on 23/11/2020, ordered bail to a rape case accused under section 439 CRPC in bail petition number 7754 by 2020, granting bail and observing that he was falsely implicated and he was in judicial custody for a period of 77 days. He was let out on bail only after 77 days. See the pathetic situation. He was involved in a case of rape, right? So such cases normally we have to take it with sympathy. The person, normally a woman, if she reports about the sexual assault, the police will take very seriously, arrest the accused and send him for remand, because the prosecutrix evidence itself is sufficient, no other corroboration necessary. Even the penetration is necessary. If she alleges that the incident takes place, definitely he has to be arrested. That is the pity here. Now let's know the incident, what happened. This happened in Kerala, Mankode, that is Mankode of some district, I will tell you. Okay, right. It is Kuppam district, they have stated. Anyway, we will come. Kollam, it's Kollam district, right. So this Pradeep Kumar is a junior health worker in Kulaputula Community Health Center. Very difficult to pronounce the names, right? So the victim, she was a home nurse. She came to her native place. She wanted to get the COVID-19 negative certificate to resume her duty. So in this connection, the so-called Pradeep, now we will call him as the accused. So the accused called her, took his house, and so that he will give the COVID-19 certificate, COVID-19 negative certificate. At that time, the COVID-19 was at the peak stage, and actually these health workers, they are the front warriors, and we have appreciated the work also. Right? Okay, for going to the work, she has to get the certificate. Already she was tested COVID-19 negative, but since he is the junior health inspector, he has to give the certificate. He asked her to come to his house. So on the fateful day of 31/8/2020, very recently, maybe 3 months back, so she went to his house for the certificate. But so quite to our shock, what happened is, according to her FIR, or she alleges that, so she was actually, her mouth was gagged, so some cloth was put inside her mouth, then both her hands were tied, even both the legs were tied to the cart, and the so-called accused person committed rape on her. And after the incident, he removed the cloth on her mouth, removed the cloth and that untied the knot, other things, and he threatened her that the consequences will be serious if she divulges the information to anybody. So being afraid of the health inspector, that too she is an employee. So of course she could not resist him, and after coming out, she went to the police station and she reported the matter. As usual, the police registered the case under sections 323, 506, 323 is causing simple injury, 506 that is criminal intimidation, then rape on being 376 2B, all these things they have been added, because an employee taking advantage of the undue influence of the employer, he has done all these things. The case was registered and he was arrested, right? So normally once he is in jail for 77 days, so applied for bail 2 times. The petition was also dismissed because of the serious allegations. A health worker going to the boss's house and actually he is subjected to her rape. It is a very serious issue, and it has come, it was widely published that the health worker, junior inspector has committed rape on a health worker. That too, it is a black mark on the health workers community, because at the time they are doing very good work, really appreciable work. The sanitary staff, health workers, all these people during the pandemic time, they have done extremely good work. But it has become a black mark. Therefore, the court did not give bail for 2 times. But ultimately, on 20th or so, they filed. Anyway, on 23/11/2020, when the matter came up, the advocate on behalf of the accused, he filed an affidavit given by the victim, so-called victim, that means rape victim. The affidavit, after seeing it, the judge was also actually literally surprised to see the affidavit, because the crux of the affidavit, what the affidavit says, that she was not subjected to rape. It was consensual sexual intercourse. So both of them agreed, and she had a sexual intercourse with him. So it's not rape. Finish. So then he was shocked. What is this? You have given a report like this, and now this affidavit has come that it was attested by a notary public. Everything is a pakka. Of course, only thing is judge did not call her to the court. Of course, the court believes only on the documents. Is it not? So, basing on the affidavit, the Honorable Court came to the conclusion that he was falsely implicated in this rape case. Therefore, taking it as true, he observed that the person was in jail for 77 days unnecessarily. Because suppose if there is consensual intercourse between two major persons, so it's not rape. Suppose if she had been a minor and her consent was obtained forcibly, things like that, definitely it would have been rape case. But now it's not at all. You cannot call it as a rape case. So therefore, the Honorable High Court felt that the actually incident of such types, they have to be curbed. They have to be actually discouraged. That is what he has. So, taking into account of the affidavit, of course, he has granted bail. At the same time, he cautioned the DGP, he cautioned the Director General of Police, Kerala State, to get an inquiry into the matter. Whether, because she stated that why have I given the FIR like that? She stated that due to the pressure of the police, I have given the FIR for the first case of rape. Now she has resigned. So the Honorable Court asked the DGP to conduct an inquiry into the matter, whether it is due to the pressure of police in the earlier stage, or now whether it is due to the pressure of the so-called accused person, that is the petitioner. Because court is not confident, it is not satisfied as to whether the affidavit is true or not. But of course, on the face of it, definitely they have given bail already. So when she has confessed that it is only consensual intercourse, we can't do anything. But inside the thing, what happened? They wanted to verify, and they have ordered the DGP to conduct an inquiry into the matter. Of course, since they cannot keep the person inside because it is against to Article 21, life and liberty of the Constitution of India. Since when the affidavit is filed, that too attested by a notary public, it is clear, it is almost equal to the chief examination statement. Right? So therefore, ultimately he was given bail with a surety of 2 sureties for an amount of 50,000 and the normal conditions that he has to appear before the investigating officer as an record. He should not threaten the witnesses. He should cooperate with the investigation. All these things are quite common. They are there. Anyway, this is a classic case where the court observed that the person was unnecessarily detained for 17 days on a false case of rape. So this is the crux of the problem. Anyway, these cases will come once in a blue moon. So please refer to such case also. Thank you.